laughing at me. They buy here cause it's the cheapest, because we abuse our labor, keep them part-time working 40 plus a week, no health insurance.
This is Steve Zeltzer with Workweek, and this past week and a half, 2 weeks, the Supreme Court has come up with a number of decisions which have, in some views, eviscerated rights under the U.S. Constitution and threaten a different form of state in the United States, where the president has complete power and no controls. And today we're going to talk with someone who's written about the U.S. Constitution from a working class point of view, a class perspective. We're talking with Robert Ovetz, who is the author of We the Elites, Why the U.S. Constitution Serves the Few, and also when workers shot back class conflict from 1877 to 1921. He is a lecturer at San Jose State University and a member of the California Faculty Association. Welcome to our show, Robert.
Thanks, Steve.
So, Robert, you've written in your books about the fact that the Constitution, in fact, was set up and organized to protect people who have property in the United States from the get-go, including slavery, that was included in the beginning of the Constitution. At the same time, there have been fights in the United States, particularly with labor, the right to strike, and the right of women and other minorities and others to have democratic rights. What is your assessment? And we can talk about some of the decisions which now are apparently saying that the rights that people think they had no longer exist. And what does this mean for the working class and the people of the United States?
We certainly have a Supreme Court that has gone even further than the Rehnquist court or the Burger courts before them in eviscerating what limited reforms have led to over several centuries of different struggles by mass movements, disruptive strikes, and so forth. And they are now moving towards essentially eliminating what little accountability exists in the Constitution for concentrated power of property. And we've seen this particularly in the last couple of years with the Jackson ruling on reproductive rights. We've seen it in a couple of cases which were actually joined by one or two of the Democratic appointees that have attempted to eviscerate workers' right to strike. And that was last session. And then in this session, there was another ruling over whether or not the National Labor Relations Board could seek an injunction when an employer retaliates for union organizing, something we were just talking about. And this is looking increasingly like a bipartisan assault on some of these rights, but certainly a 6-3 supermajority of the court is really out of control. We can talk about these decisions that came down last week, but it's certainly out of control in carving an opening, an unobstructed opening for owners of property. And one of the things that a lot of people just don't realize about the Constitution, and you were referencing this, is that property is protected all through the Constitution. And they use what George Carlin called weasel words to avoid using the word slave or slavery. And all through the Constitution, over 20 times, there are protections for slaves and slavery, owning slaves, owning human beings and exploiting them and dominating them. But since slavery was taken out of the Constitution, except for prisoners in the 13th Amendment, those protections for property still exist. And we have a court right now that is going out of its way to even further expand those rights for property.
Well, one of the issues that labor is facing as far as an environmentalist is the Chevron decision, which says that the government agencies can no longer be given deference as to how a bill should be implemented, and it will be up to judges in labor, NLRB, at the Environmental Protection Agency, and government agencies. What do you think this is going to mean for the working class and the ability of workers and community people, environmentalists, to protect their conditions and their environment?
This is actually a case that came down in the last week or so that actually overturned that long-standing precedent called the Chevron Doctrine. And the Chevron Doctrine essentially established what had really been an ordinary separation of powers issue in the constitutional system until that point, but it enshrined it in longstanding precedent. And that is that when Congress hasn't specified for any other reason, the executive branch has the ability to make what's called administrative law. And administrative law is made by that part of our court system that a lot of people are not that familiar with. So we tend to focus on what are called the Article III courts, where you have civil and criminal cases, and they go through the district, appellate, Supreme Court level. But also in the federal system, the executive branch also makes law that we otherwise call regulations. And those are done by administrative law judges. And what the Chevron Doctrine did was back about 40 years ago, was it said, these administrative law courts can interpret what Congress intended when it passed the law so that they can make regulations. And only under extreme circumstances can you bring a case to challenge that administrative law. For example, if it violates the Constitution or if it's not being executed according to the law, et cetera, can you bring suit? So what this case decided last week was that the Chevron decision doesn't apply anymore because the court shall always have the ability to be the final adjudicator of what Congress meant. And this puts the courts in an incredibly powerful position of interpreting what the law means. And it has good and bad consequences. For example, it will eviscerate the ability, for example, the National Labor Relations Board to be able to go into a case and then make a determination, for example, whether or not there was an unfair labor practice committed by an employer. It looks like this is no longer going to be possible because in every case, they're going to have to go to a federal court and say, we think that there was an unfair labor practice conducted by an employer, and we want to issue an injunction. And so every time, and the National Labor Relations Board doesn't seek injunctions very often. That was another case that was decided a few weeks ago. That every time it wants to do that, it's now liable to have to go to a federal court. So the flip side to that, of course, is that we no longer have these even less accountable administrative law courts making determinations. And then we have to go to federal court to sue. But it's just going to put another roadblock and impediment in the way of getting action by the executive branch. Now, I'm not as cynical about this as you might be hearing some people talking about this Supreme Court case, because when it comes to some types of regulations, it can actually take years, sometimes more than a decade, before an administrative law court actually issues some determination on whether or not a regulation has been violated. And also those executive branch agencies can also take a very long time to come up with the regulations. For example, we still don't even have concrete emissions restrictions on coal burning power plants and gas burning electrical plants. And that is something that was started back 20 years ago. So this case could have different kinds of outcomes depending on which side of the issue you're on.
Well, one of the promises that Trump has made is that he's going to bring in thousands of people, fascist people, Turning Point USA, to administrate this state. And agencies like the NLRB and other agencies are basically going to be controlled by people who want to destroy them and open union busters and to shut down any action by the NLRB. What does that mean? And the fact that the NLRB was set up after the 30s, after mass mobilizations, general strikes. Today is in San Francisco is the 90th anniversary of the San Francisco general strike. It was out of the general strikes in Toledo, in San Francisco, in Minneapolis, and other strikes that the NLRB apparatus was set up by Franklin Roosevelt to ameliorate and to deal with workers' movements. If there's the destruction of the NLRB, which is quite possible, if Trump is elected. What is that going to mean for the working class?
Well, I'm quite cynical about the NLRA, the National Labor Relations Act. I think that labor law is actually an impediment to our ability to organize. Nevertheless, there are times when the National Labor Relations Act can be used to our advantage. So in the cases of unfair labor practices, also in getting official recognition that forces an employer to actually meet and negotiate. However, we know that the outcome of that is that they don't actually have to come to an agreement. And there are many instances of interfering with the ability of us to organize and delaying the process so that it never comes to a vote or we never are able to actually negotiate a first contract. So there's a lot of problems with the National Labor Relations Act. However, those problems that we face, those are beyond the pale for the ruling elite who don't want to have any sort of labor law at all. And I think that if they get what they really want, they're going to see a return to that period that I wrote about in my first book, when workers shot back, when there was no national federal labor law. There were a few states that had some. There were some arbitration schemes like during World War I, and it was a really brutal class war when employers tried to hire thugs and literally shoot at and kill workers that were trying to organize, and workers organized in self-defense and fought back. The two big general railroad strikes of the end of the 19th century are examples of that, and many other examples prior to the passage of the NLRA. So we have huge corporations like Amazon and Tesla and Starbucks that are gunning for declaring that the labor board is illegal and unconstitutional. And what this ruling does is it moves a step closer to essentially eviscerating the ability of the board to do anything. And again, this can have benefits and disadvantages. If the labor board can interfere on behalf of workers, it also can interfere on behalf of the employer. So, I think there's possibilities where, this could be used to our advantage. But again, this ruling, repealing the Chevron doctrine, doesn't just affect labor law. It affects essentially everything in the executive branch. Countless numbers of regulations and administrative law rulings that are, we don't really know whether or not they have to be abided by, whether they can be enforced anymore.
And of course, that includes OSHA and other protections for workers on the job, which in California, there are less than 200 inspectors for OSHA. That's under a Democratic governor, Gavin Newsom, where you have 18 million workers with 200 inspectors. Now, the issue of the NLRB, right now, a lot of union elections in the United States are being done through the NLRB, particularly in the South, elections of Mercedes-Benz, VW. If there are no more elections and they shut down the elections, what is that going to mean to the trade union movement and workers in this country who want a union?
Well, I'm not sure it's going to shut it down, but I think virtually every step that the National Labor Relations Board is going to take will have to be reviewed by a court, and that's going to bog down the courts. That could mean even longer delays until that election happens. And then, of course, longer delays when employers carry out union avoidance and suppression measures, and the board won't be able to intervene. So I think what that's going to require is that, and this is something that I've been writing about for years and write about in The Chief regularly, is that we need to look beyond labor law in order to organize. And in the ways that I was just talking about, labor law is really an impediment to organizing in many cases. The average time to get to a first contract is around 2 years. Many organizing efforts that get recognized never even get to a contract. And this is built into labor law. It regulates our ability to organize, and it gives the employer advantages. And so, I really kind of follow in Joe Burns's approach, that we really need to organize against labor law when it stands in our way. And so what this case does is it just puts more roadblocks and impediments in our way.
And one of the other issues that took place is the immunity, the ruling that the president, and they have a view that unitary power, that the president really should be above the Congress and above the courts. This ruling of immunity, what does that mean for the working class in the United States and the mass of people?
Yeah, so it's funny that you're asking about that because this is going to be my next piece in the chief. And there's some extraordinary consequences to this ruling of Trump versus the US. But I think that the primary takeaway from this ruling is that the president is now above the law officially, according to a Supreme Court ruling. The majority literally wrote in their ruling, quote, "The court thus concludes that the president is absolutely immune from criminal prosecution for conduct within his exclusive sphere of constitutional authority," unquote. Now, we've known this for over 200 years, starting with President Washington, that presidents act all the time. They make law, they invade other countries, they carry out assassinations, they break strikes. There's been literally no accountability. And every time a president acts and they create new powers that don't exist in the Constitution, the next president after them gets those powers. What we've always taught ourselves in our system is that the president can still be held accountable through impeachment, potential prosecution, which, by the way, is allowed still in Article 1, Section 3, where if a president or any other executive is impeached or judge, they can be banned from office for life, and they can also still be prosecuted if there's a criminal offense. So the Supreme Court really kind of contradicts that section, but effectively it says now the president, if they claim it's an official responsibility, is now no longer able to be charged for a crime. So the way I explain it is, President Trump gets elected and it's looking increasingly like he will win, which is disturbing in itself. A convicted criminal who may end up serving from a New York State jail unless it gets overturned by the Supreme Court ruling. He could decide, I want to assassinate Robert Ovetz based on secret evidence. And I'm assassinated, and it has nothing to do with his official duties. And he can just say, that was part of my official duties, and I have secret evidence, and I don't have to disclose it because I have a national security exemption. And there's nothing anybody can do about that. So it might seem like an extreme example, but presidents have been doing this for hundreds of years. So I have mixed feelings about this ruling as well, because while the liberal justices issued these incredible denunciations of making the president a king, the liberals and Democrats have gone along with this for over 200 years. They have looked the other way when it's a Democratic president doing these kinds of things, and then they shout fascism, dictatorship, abuse of power when it's a Republican doing it. It's a bipartisan agreement that presidents have unlimited power. Now, here's the thing in the Constitution. Article 1, Article 3 are very specific about the limits of power on the legislative and the judicial branches. Article 2 does not have a clear limit. What's the president's limits on their powers? And remember, presidents were originally elected and could serve for life. They could run as many terms as they wanted until we amended the Constitution in the 1950s to limit them to 2 terms. So the framers designed the Constitution to give the president unlimited powers anyways, a kind of elected king. And Washington ran unopposed twice. So I think that this case really just makes it very clear what has always existed, and that is that we have allowed presidents to be above the law.
Well, at the same time, there's a rise of fascism internationally. Argentina with Milei, in Italy, Meloni, and Orban. You see that as a threat to bourgeois democracy? And do you see any difference between fascism, actual fascism, and what we have today?
Well, I think there's elements of fascism in what we're seeing emerging around the US, but there is a wave of overt and fascist influence parties coming into power. It's very likely to happen in France this weekend. Um, Unbelievably, in a country I lived in for 6 years, a fascist by the name of Geert Wilders is now the largest party. His party is the largest party in the Netherlands and controls the government. We're seeing it spreading all over the world. But one of the things that should be most concerning for us here is that we have somebody who literally said a few months ago that he will be a dictator on day one. And we should take his word for it. And we now have a Supreme Court that's saying, okay, you can be a dictator and we're not going to hold you accountable for anything that you do as long as you claim it's an official duty. The other case that came down also in the last couple of weeks was a case for one of the January 6th insurrectionists who followed Trump's order to attack the Capitol and had his charge thrown out for obstruction of an official proceeding. And that's very disturbing as well, that the court limited the definition of official proceeding to exclude Congress, which is just mind-boggling. And one other thing I just want to mention about the Trump versus US case is that, and I read most of the 119 pages of that ruling yesterday, is that they actually said, the majority actually said that Trump's attempt to pressure Vice President Pence to disrupt the counting of the electoral votes was actually an official act of the president. It actually says that in that ruling, and I'm paraphrasing here, but that shows you how far this court will go to help Trump get back into power, knowing the man that he is. And that should worry all of us. And I think that the best solution here is that our representative system democracies, checks and balances, whatever extent that they've worked, no longer work. And we as workers, we need to really start using our power and overcome the limits of our ability to organize, because this is the last line of defense against fascism in this country.
Well, one of the issues is that you addressed is that the Democrats and Republicans have a bipartisan policy of going along with the expansion of presidential power, assassination of U.S. citizens, for example, that they've allowed. Isn't it the case, though, that there is no political alternative? There's no working class party, working class organization as an alternative. So you have a political vacuum politically in the United States and internationally.
Well, I think that's unfortunate at the moment. I see some hopeful signs that some of our unions are being taken over by rank and file groups and re-energized. But at the same time, far too many of our unions are controlled by business unionists, labor liberals, those who are too close to the Democratic Party, and we have a long way to go. But there are many of us who are organizing across our unions and outside the leadership. And I think that we're seeing a warning light go off in this ruling, to quote Justice Jackson. This is a red light warning for what's left, if we could call it a representative democracy even. And it's emergency time. This has disturbed me for the past week, that the court would be so blatant about this. But you're right, there's a power vacuum, but also that gives us a lot of opportunities to construct a new approach and a new strategy.
Well, do you think workers in this country are prepared? For example, there are corruption charges against Sean Fain, and the UAW is still under a monitor. Under a Trump administration, they could, using that justification, put the UAW in trusteeship. Of course, Sean Fain called Trump a scab and said he represented the billionaire. So he has reason politically to go after Sean Fain. In the case of Sean O'Brien, he said he's going to the Republican convention, despite the fact they did a survey and the members of the Teamsters said they support Biden. So why would he be going to the Republican convention? I mean, it seems, as far as direct intervention by the U.S. government into unions, for example, that move left, there could be a takeover by the state of these unions. Do you see that as a danger?
Oh, yeah. I mean, that's certainly a danger. I think Rash Research had a good idea as a way to protect union assets, that there are some strategies to do that so that if they are trusteed, those resources are no longer subject to that kind of outside control. Um, but I also think that there's also a big risk of continuing even under a Democratic administration. And that risk is that, the Biden administration, Democrats in Congress have shown that they're willing to break strikes. And, one thing that's coming on the horizon that you haven't mentioned is that virtually every flight attendants union in the airline industry has authorized a strike vote, has voted to authorize a strike. And we could see a general strike happening that will shut down the airlines, potentially even before November. And what's the response going to be of the Biden administration if they're facing a general strike in the airlines and they're hanging on by their toenails in this election? I think we face another risk there as well.
And of course, in the last confrontation with labor that Trump had, when he shut down the US government and refused to pay the workers, federal workers, the airline flight attendant Sarah Nelson threatened a general strike of the flight attendants, and because of the security, health and safety conditions, security. And 4 hours later, Trump was forced to open up the government.
Yeah. No, I mean, that is a powerful tool. I think also the transport workers union also threatened a general strike as well. And then one other thing that we should also be very concerned about is the attack that's been renewed against the Vermont State Labor Council. I'm not sure you're familiar with this.
I covered that and interviewed one of the members
Yeah.
of Vermont
Okay,
AFL-CIO.
good.
And
Yeah, because
Liz Schuler, the head of the AFL-CIO, is actually coming down on them.
yeah, they've reversed their leadership vote. They threw it out. So, we have a concerted action by some of the established officers in the unions to really undermine rank and file democracy in our union. So, that's another level of this fight as well. And it's part of the reason why there's a power vacuum. Because whenever we organize and try to assert ourselves, there's some sort of internal sabotage or roadblocks and impediments or labor law that stands in our way. The examples you gave, and what's happening to the Vermont Labor Councils are also good examples of that.
And the AFL-CIO, most of the national unions in the United States are pro-capitalist, pro-imperialist, and pro-Zionist. And that seems to be a political problem, challenging capitalism and challenging the U.S. war machine, which has now a bipartisan war on three fronts: Ukraine, Palestine, and China. How is this going to change? And how is the Constitution involved in that as well? Because it seems under the Constitution, the president has great power to lead war.
Well, actually, the president doesn't have any power in Article 2 to start a war. The war powers are rooted in Article 1. Congress has to declare war, and then it gives the authority of the president to run it. However, both parties have not declared war since the last declaration at the beginning of World War II, which I think it was Romania or Bulgaria. So both parties have exploited that and continue to give the president incredible authority, not only to declare war, but overthrow governments, carry out counterinsurgency campaigns, assassinations, imprison journalists like Julian Assange, or keep them in prison in other countries. It's a long list. And selling arms to brutal monarchies like Saudi Arabia, or settler colonial countries like Israel, where half my family lives. Unfortunately, this is something that both parties continue to do. And it's a huge problem when our unions are too closely aligned with one of the parties, and then their foreign policy overlaps. And it's not a new issue. Unions have, unfortunately, the leadership have long been attached to U.S. foreign policy. I'm going back to President Wilson. Samuel Gompers tied the AFL to Wilson's foreign policy. And ever since then, unions have been doing that. Kim Sipes has an incredible book about that history of the AFL-CIO. So it's certainly a problem, but dozens of large unions have called for a ceasefire in Gaza. But unfortunately, so far it's just a statement. And for example, if the ILWU's president is taking free trips to Israel and aligning with Israel, and refuses to allow the members to stop working ships that are going to or from Israel or resupplying Israel, then we've lost one of our key disruptive tools, which helped bring down apartheid and help resist fascist dictatorships in different countries over the last half century. And so we need to reevaluate our strategy of how workers here can help stop that genocide in Gaza.
Well, one of the things that Bannon and other supporters of this project, they call it Project 2025, is they say that there's going to be a civil war in this country. And the issue of what happened in the South, the fact that the Army left the South before Reconstruction was completed, that the black workers were indentured as basically slaves in the jail system, producing as indentured servants in the farms. Not indentured, they were in prison and being let out of prisons to work in plantations. You see that this fundamental confrontation that we're going into now is going to open up the question of what kind of revolution we had, what kind of revolution we need to defend the working people of the United States?
Well, that's a big question. And, like I like to say, I don't have a crystal ball. I don't know what it's going to be, but I know that what we need to do right now is we need to have a really open and transparent conversation and discussion about a new strategy, because the strategy that we've been using is not working. Day by day, things continue to get worse. Whatever victories we have are small incremental victories. The workers' movement is really kind of stuck in reverse. We're still over relying on collective bargaining and legal forms of job action, and that's just not getting things done. And in terms of what the right would like, my understanding is that there are factions on the far right that would like to trigger an armed confrontation, and that's not something that anybody is going to win, except those who have the guns. That's not what most of this population is willing to get behind. And it's not a strategy that's a winning strategy, even from the left. I think where our power lies is our ability to disrupt the capitalist economy by withdrawing our labor. And unfortunately, there's too many roadblocks and barriers to us being able to assert that power. If we're going to bring about change, that change should be the locus of that change has to be in changing the economic system, because this economic system is toasting our planet, and the other strategies just aren't working. And I really think that there's too much hesitancy and again, roadblocks and barriers to us having a conversation about strategy. And that's really unfortunate. But there are some good places where those strategic discussions are happening, and they need to be vastly expanded and done quickly.
Okay, well, I want to thank you very much for joining us. We've been talking with Robert Ovetz. Again, he is the author of We the Elites, Why the U.S. Constitution Serves the Few. Also, When Workers Shot Back, Class Conflict from 1877 to 1921. He's a lecturer at San Jose State University, a member of the California Faculty Association. So thanks for joining us. And we need to continue this discussion. People should look to the chief for your articles. You have a regular weekly article that you produce.
Thanks, Steve.
Thank you. Take care.
Bye-bye.
Bye.